I went to the, I don't know, however you want to look at it, the dark side. They paid more money, and I represented agencies for about 4 years. And then for the last 20 years, I've been on my own, representing children and often foster parents, and also doing a lot of training all around the country, which I absolutely love to do. And I want to talk a little bit about concurrent planning from the point of view of how does that look in the legal arena, what should be happening in court around concurrent planning, and why should lawyers and judges who are here to have a donut and get some CLE, why should we even care about this social work thing that other folks are doing? What does that look like? So I think we're going to go through that. We're probably going to take a break then and have a little bit more dialogue. Thrilled that people are talking. We always say to each other, nothing is worse than training the dead if everyone's just sitting there, arms folded, not talking. Here's what I think. I think that the legal system has traditionally not really wanted to get into this concurrent planning. I think there's a lot of discomfort on the part of attorneys in particular and judges saying, that's the social work stuff, that's not what I do. I come to court and say, there's been no adjudication and I just won for my client. He's not a father, so we get to walk out the door, not realizing, of course, that that really just ended up being a significant problem for the client, not having a relationship with their children. I also think that this is what caseworkers think. I haven't heard it here today, and I'm hoping that's because it isn't so. But I want to say that when I'm around the country, I hear a lot of caseworkers say, the last thing in the world I ever want to do is talk about concurrent planning in front of the court. Because I think it's something I believe in and that I want to do, but I am not going to stand there and in effect get ripped up by defense attorneys or other people who think I'm really not trying to get this kid back in the home because I've got this other secret plan. The problem with caseworkers not discussing it in court is that it makes the plan be a secret, which is exactly the opposite of what we're talking about here in the context of full disclosure. I also have to say, as an attorney who's listened to a lot of presentations like that, and particularly listened to a lot of discussions about teams and collaboration, I often sit there and say to myself, you know, that wasn't how I learned to be a lawyer, and certainly not a trial lawyer. I'm an adversary. There are people I intend to cross-examine. I intend to argue that they're wrong, and that's really not in the same team and collaboration spirit. So how does that sort of all work together? How do I be a lawyer? How can attorneys and judges embrace this concept, but in essence remain what we are, attorneys and judges, and not a part of the agency? We have 3 branches of government, and we believe in this country that the court system is a check and balance to the executive system, executive power branch of the Child Welfare Agency. So how does that work if we're doing collaboration, and we're going to talk about that. And let me just ask whether some of the attorneys in the room listening to the conversation that we've had so far have had some errant thoughts. I know I had these. These are thoughts I had the first few times I heard about concurrent planning. I was not necessarily sold on it. And I said, you know, exactly what we commented on earlier. Concurrent planning, to me, the example always seems to be reunification or free the child for adoption. And therefore, isn't this really about making sure caseworkers can get to the freeing the child for adoption part quicker? And if I'm defense counsel or I'm representing a child and that's not my goal, why would I want to make it faster for them to do that? Why would that be something that I would embrace? Or maybe you say, some of you might not be willing to say it out loud, but some of you may have been thinking, I think our caseworkers have enough problem trying to figure out how to get kids back in the home. You're asking them to do even more than what it is that they're having some struggles with. I'm not sure that really is going to work. Or, you know what, I just don't think this is fair to parent. This is all about telling the parent from the beginning, by the way, this is what's going to happen to you if you fail. And how does that feel to the parent? And what about the confusion? Isn't this going to confuse parents, confuse foster parents, confuse children? Do we have one goal here or do we have 2 goals? How much energy is supposed to be spent on this other goal, the one I really don't want to have happen? I'm not seeing a lot of response here, but I have to believe there are some people in the audience who have had some of these thoughts as we've been talking about it. Why is this anything I even have to come here and listen to? Isn't this really something about what caseworkers do? Or your attorneys for agencies will often say to me, the last thing I want is for the caseworker to talk about concurrent planning in front of the judge. The judge hates it. The judge doesn't want to hear about it. The judge wants to know, are you doing your job to get these children home? I don't want to give something for yet more for the parent's attorney to argue and open a wedge that the caseworker is really not talking about getting the child returned. I think these are real thoughts that attorneys and judges have about concurrent planning. I had them early on, and I'd like to talk about those things and maybe how does this concept really fit, and if we believe in this and we want this to work, and all the things that Stephanie said are things that we really want for our families, then how is that going to look in this adversarial process that we have that we call court? Is it really just the flavor of the month from the caseworker folks, or is this really something that helps kids? Does it also something that we can do in the court process itself, and does it really achieve timely permanency? I think the answers to this are yes. I've become convinced after seeing it happen around the country, and I actually believe it is what lawyers and judges already do. And like often in these kinds of discussions, perhaps we in the legal community haven't consciously thought about what this is, but it actually is in most cases something that I think that we do. For example, if you are representing a client who's charged with a criminal case, and you talk to the client about it, and you say, you know, what do you want? What do you want us to do here? How can I be of assistance? Well, I'd like you to take my murder case to trial, and I'd like you to win that case, and I'd like to walk away free. Okay, that's the goal, and I can do that for you as an attorney. But I have a job to tell you about the possibilities and the probabilities of that. What will that mean? What is my assessment to you of the likelihood of my actually being able to win your murder case? And maybe we need to think about the plea bargain that the district attorney is offering. Or maybe we need to consider some other alternatives here. That's what lawyers do. We are paid for our assessment and judgment about the possibilities and probabilities in a case. So that when a parent says, what I want you to do is get my kids back, get the department off my back so I don't have to deal with a caseworker, so I can go do whatever I want to do. If that's the goal, then often an attorney will have to say to a parent, we can try to achieve that goal, we can do what we can to focus on that goal, but you may need to face the fact that there is significant evidence that you have a drug problem, and it's extremely unlikely that the judge is going to give you the children back tomorrow and let you walk out of the courthouse. So let's think about what our backup plan is, or let's think about what an alternative is to argue. If you're representing a child as a GAL, I think the same thing happens as well. I'm aware here in Nebraska that you have that dual role, but if you have a child who's old enough to articulate what they want, surely they often say, 7, 8, 10-year-old children, I want to go back home and live with mommy. I know she's hitting me. I know she uses drugs. I want to live with my mommy. And again, possibilities and probabilities. I think the attorney has to tell that client, I can ask the judge for that, or I will articulate that that's what you want. I'll tell the judge that you want to return home to your mom. But I don't think the judge is going to let you go home to your mom today. What would you like if you couldn't go home to your mom? Would you rather be at your grandma's or at your aunt's house? It's those things that we kind of already do. And the concept, I think, of having a more open and honest discussion about those options in the courthouse, I think benefits clients regardless of who you represent in the child welfare system. It also means things are going to move along. And although sometimes, to be perfectly honest, a defense attorney's decision might be to stall a case and might feel that that's beneficial, generally speaking, most times we do want to move the case along. The client wants a resolution. What is it that I have to do to get my kid? Well, if I'm not going to get them back, let's get going on what I have to do to to get them back at some point in time in the future. Moving the process along is generally what we're going to want, and being less linear and doing things concurrently makes a savings of time for all. I think that if lawyers and judges are also being concurrent about what they're doing, as well as urging and openly discussing the concurrent planning in the courtroom, concurrent planning becomes much more of a reality. It really can't work. It can't work if the caseworker is doing it out there and nothing's happening in the court that connects with it. At the basic level that doesn't work is full disclosure, because if it is a secret in the courtroom and not being openly discussed, then it's the same thing that happens a lot of times with clients. They're hearing what the caseworker says, sort of, but it doesn't really mean anything, because when they go into court, no one else is speaking about it. It's just something the caseworker is saying, but it's not being reinforced by what's happening in the court or what their attorney is telling them. Okay, so if that's true, if you have heard what Stephanie has to say and you're saying, yes, much of that makes a lot of sense, and I want to make sure that is happening in the courtroom, what does that actually look like? I mean, what is that supposed to mean? What would we actually be doing in court that would be assisting in concurrent planning at the same time we're promoting whatever our client's perspective is going to be? And this is what I think it is. I think we've already started to talk about it right here. It's doing things in the early stages of the legal proceeding that help the concurrent plan. And here's the cool thing about it. These things that help the concurrent plan, we're already legally required to do them anyway. We have to do them because we're legally required, and they are the things that are going to help with this concurrent planning. So I don't mean that everyone is going to say, who's your daddy, to people in court. I hope the judge isn't going to lean over and say that to the child. But I do think that this underscores, in my mind, the key questions that have to be asked in the courtroom setting, so that everyone is aware of what's happening regarding these required issues that are also the basis for concurrent planning. So who is the father of this child? Who is the fathers? Who are the fathers of all these children? Where are they? Have they been told about what's going on? Can they be a resource? What's going on about that? Open discussion in court. Where are all the relatives to all of these children? Have they been notified? Who actually has been notified? Give me a list. Who and what is the answer? What did they say back? What are the things they may want more information about? Someone is interested but needs more information about money. Someone else is interested but they're 4 states away. How would that look? Those things should be being discussed in the courtroom in front of all of the attorneys and the judge. Where is everybody? Are there some people who are several states over? What are we going to do about that? How will we approach that? Can there be a situation where the child remains nearby for the goal of reunification, but at the same time someone in another state is being looked at as an alternative goal? What would that really look like? And what about Native American ancestry? Do we have an ICWA child? Do we have an Indian Child Welfare Act case here? And how is that going to be of assistance? Well, it's clearly a concurrent plan scenario where the tribe or the Indian nation can be of help in determining what options there may be for these children. So what about who's your daddy? What are we actually looking at there? We have really seen around the country that this is probably the biggest time bomb, the biggest explosion. Do we have to do this? Absolutely. This is constitutional. This can't be anything that any lawyer or judge would question. That if this child is having this legal proceeding about what's going to happen to them, where they're going to live, what their future is, their parents are entitled to know, and the child has a legal right to have those parents be informed. So we're required to do this. But doing this is also concurrent planning. Where is this person, and can this person provide financial support for the child that may assist in the situation? If mother's struggling to get the child back in her home, one of the things that might enhance that is whether or not we can locate, identify, adjudicate someone as the father who might be able to pay some child support. Is this person a possible permanency a resource for the child? This is something that I'm glad to hear has been, some people feel is starting to change, but this is a real issue in the child welfare world, that that belief that we took the child from custodial mom and therefore we are responsible to work to place the child back with custodial mom. No, our responsibility is to get a child out of foster care. And if a non-custodial parent can do that quicker than the parent we remove the child from, then that's something that we're going to want to do. Yes, ma'am.
I was just, when we do, in my area, we'll do the pre-hearing conferences, and at that initial meeting, you have the family members, the parents that are involved, you know, whether it's mom, dad, whatever, they are not so likely to come up with names because in their minds, this is a temporary situation. When then, a year down the line, they try to have a pre-hearing permanency conference 45 days prior to the 1 year mark. And at that point, that's when we'll get information. We'll get extra people because at that point, it's suddenly in their face, look, this is looking like you may not get your child back. You need to start coming up. And then we'll get names. Then we'll get resources because that's, sometimes it takes it to get that far for parents to see what they're looking at.
And we want to change that. And there's two ways I feel that attorneys and judges can change that. One, the attorney for the parent needs to help the parent understand how it's going to be far more helpful and valuable to bring forward those names right away. And second of all, for the judge to underscore that. It's happening in a meeting, but it also needs to happen in the courtroom with the judge asking and the judge underscoring. And the power of that robe is tremendous. And the same questions, I know you've seen this, the same questions that have been asked by a caseworker or asked in a setting like that, now being asked by the judge from the bench, can make a huge difference. So I do think that's exactly what we're talking about, and that's the thing that we need to change. We need to help people see why identification earlier on is more helpful. One of the things you can say, I think, to parents or relatives who are reluctant to identify the father, reluctant to identify other relatives is, you know, it's not going to help for that father or that relative to come in later on in the case riding the white horse, here I am, I'm going to take the child. If the reason you won't disclose this person's name or tell us about him is because you think they shouldn't get the child, they're a problem. I'm running and hiding from this man who fathered my child. He is violent. The last thing in the world I want is for him to be brought forward as an option. Then it's better that we hear that now. It's better that you've provided that information at this point so that we can look into that. I don't want my uncle to be used as a resource for the child. He sexually abused me when I was a child. We need that information now because if that person shows up later and we don't have the information, then that's going to be a much worse situation. We also want to remember that this parent, even if he's not yet been identified legally as the father, you know, that child has a right to that information. Who are my parents, and a right to whatever support or assistance they can provide, as well as the father having a right to that information and the option to parent, the right to services. That is a problem in our system. We focus on, you know, we've removed the child from this parent, they have a right to services to get the child back. There is also a right to services that the parent has whose child is in foster care. It's not maybe their fault the child is in foster care, but there's some reason that the child isn't going to them. If we find the other parent and everything is fine with that parent, then the child needs to go to them. That's really the only thing that can be done from a constitutional point of view. That parent has a right to the child as opposed to the government having their child. What usually happens for us, what we experience is we locate the other parent and there's kind of a reason that they haven't been involved. They have their own drug problem. They don't want to be involved. They've started a new family. This isn't part of what they want. That person needs services and assistance as well. It may not be their fault the child went into care, but it is their fault on some level that the child's staying in care. And if our goal is to get the child out of care, then services have to be provided to that person who has not necessarily been identified as an abuser or neglector.
So not to sidetrack the conversation,
Yeah.
talking about fathers who are caring for their child, the child's been placed with them, or we have identified no concerns. Can you talk a little bit about custody? Because that seems to be one thing that we struggle with is we're involved in the child welfare system in juvenile court, and now the desire is that custody should be established. And so the child welfare, we're kind of saying that there's no safety concerns for the father to continue to be involved, whether they've intervened and they have temporary custody or they're in that process. Can you talk a little bit about kind of what you're seeing nationally in regards to custody for fathers?
What I'm seeing nationally is, I sometimes think, difficult for caseworkers and social workers, and I think there sometimes is a bit of bumping here regarding parental rights and the desire to be of help. The scenario that you're talking about does happen, doesn't it? We've removed the child from custodial mom, and maybe she has a court order, maybe she doesn't, but she's got the child. And we've removed the child from her and maybe her current boyfriend or the father of her last child. And we reach out to this other father who kind of says, you know, I didn't really know things were that bad, and here I am, and I got a new wife, and I'll take my child in, and we check out this person, and we really don't have any concerns. And there's this sense, I think, in our system, well, that's not fair, meaning sort of it's not fair to her that he gets the child. Well, that's what the system's supposed to be about. What we're supposed to be about is getting the child out of foster care. And I would argue from the father's point of view, that's unconstitutional to deprive me of my child when I've done nothing wrong. Now, sometimes there's an element of where you've been and how come you didn't know this was happening. And if there's neglect there on that person's part, they literally have walked away knowing birth mother has a terrible meth problem, well then they are neglectful as well. But sometimes there are situations where you can really see how the person didn't know it was that bad or didn't know there were that many problems going on. And although they were not paying as much attention as they should, maybe it doesn't rise to the level of neglect. And the argument would be that parent, that father, doesn't have to have government involved in his care of the child. Well, wait a minute, doesn't mother deserve services? Well, an agency could make a decision. We're still going to provide services to this mom. Maybe she has other children that you're trying to get back in the home. Maybe she's expecting or is likely to have another child. Maybe you're still steering her to services. But our goal is to get children out of foster care. And if that child has gone to a parent that doesn't need governmental intervention and we have problems with limited services, what's happening in other parts of the country is that's the end of the child welfare case. We have kept that child safe and they are with a parent.
So part of our struggle has been the concern that the mother would come back if she has the custody order or whatever, that
Right.
she would come back.
Yes.
Be able to, not the best term, fight the father or
Right.
Have that child come
Yes.
back to her. And we're kind of saying, but time out, the child welfare system, we've done what we need to do there with a safe, protective
Right.
parent. We should not continue
To be involved in a private custody matter.
Custody should be given
Correct.
to the father.
Right. There are lots of ways people deal with that around the country. For example, some of the court orders that are given to the father in that regard, a custody order, may put information directly in the custody order. This custody order has occurred in response to docket number da-da-da-da, in which mother was found to have neglected the child. It may well be that some people call this loading the order, that people load the custody order with clear information. He cannot provide mom can't allow unsupervised contact with mom, order protection type language in there. Clarification, some people do, a clarification that if the parties come back to court talking about changing the visits or allowing mom custody, that the agency will be alerted and will be a party to any said action. There's lots of ways of doing that in a legal structure. That doesn't mean that what we're going to do is have as our goal helping one parent get a child back from another parent. That's generally not what I think has been the definition of a child welfare goal. In the back.
I can think of 2 times in our jurisdiction where we have actually closed a case without clarifying the custody. And in both situations, it ended up horribly.
Yeah.
A week later, the mother went with law enforcement officers to get the child, and if her custody order said she has custody, they have to return the child.
This resolving of an abuse case or neglect case with a custody order has gotten very sophisticated because of those kinds of issues.
And the second one, after we were out, the father just went ahead and returned the child to the mom anyway.
Yeah.
So, I mean, you really do have to consider the custody. I think one approach way we could do it is vacating HHS and having place the child with that parent, and then give that parent an opportunity to establish a custody order. That gets
Well,
agents
yes,
out of the picture.
yes.
Yeah.
And I don't know enough about your statutes to see how this would work, but I can tell you that in other states, the statutory system has evolved to the point that the resolution, the dispositional resolution after the adjudication of neglect and abuse can include custody, the concept of custody, the full custody that you would give to any parent, and the ending of the involvement of the agency, because we've adjudicated one parent to be neglectful, and our resolution is that the child has custody with the other parent. Judge?
Would you discuss the issue of an out-of-state parent that you would place custody with versus the reasonable efforts that have to be made to return that child to the original custodial home, which includes parenting time and all of those other issues?
Yeah, this is like giant. I could spend the rest of the day on that one, Judge. The one thing I would say is the concept, the second piece to your question, the concept that I'm talking about is, does there come a point in time when the court is making a decision, this child is going with the parent that did not have the child to begin with, let's call them the non-custodial parent, and there isn't going to be efforts to return the child to the custodial parent, the original, because I'm giving custody to this other parent. I've determined this parent has neglected, and yes, I want her to get off drugs and improve her life, but right now, the child's being cared for by someone else, and therefore, I'm not going to order ongoing services have to be provided. There's no reasonable efforts to reunify if the child is with a parent. We reunified them with the other parent. They have been reunified. But the other issue I think that you might be getting at is the ICPC issue regarding the other parent. And I'm hoping people are aware that a couple months ago, the ICPC did clarify this issue in their regulations. If you're not aware, you really definitely want to read this and be aware of it. And that is, the ICPC is regulation number 3 says very clearly now, the out-of-state parent that you did not remove from, what we're calling the non-custodial parent, does not need ICPC, does not need ICPC if the following factors are true. That person did not have the child to begin with, you did not remove from that person. That person intends to, or the intention of the court is to ultimately give custody and end the involvement of the agency with no supervision or ongoing services, and the court does not have before them any evidence that that person is unfit. You don't need ICPC to do it then. And I think that's a really big deal. An interesting issue, I think, Judge, that's going to happen for a lot of us is, what is evidence of unfitness? Do you know what I mean? So if mom says, please, Judge, don't give that child to dad. The reason I'm living here is I ran from him, I hid from him. Here's all these court orders, orders of protection. He did these terrible things. Now you have a question of fact before you. Is he fit or unfit? I may need an ICPC. But suppose, just suppose, I don't know the answer to this, I'm not on the bench, but suppose mom has a very serious mental health problem. And she's saying, please don't give the child to the child's father. He's possessed by the devil. And I know that he will use the child in his satanic rituals. And suppose you assess and say, there's really no evidence of that whatsoever. This is part of mom's mental health problems. Then I think an argument could be made. If you're not feeling that the question of fitness has been raised to you, then you don't need the ICPC, and you can make a decision about an ultimate resolution that would be custody of that out-of-state parent.
What about the issue of there's been no contact with the non-custodial father, issues of abandonment, but otherwise dad looks pretty darn good. He has a new family and 2.5 kids and a dog, and otherwise looks really.
Could he have a cat?
Yeah. So that, what you have though is that does the fact there's been no relationship, is that enough to determine unfitness under that regulation?
We're going to have to wait for some judges to make rulings on that. I mean, I could imagine a judge saying, I don't call that fitness. I have every reason to believe he's fit. I'm not doing it tomorrow because I'm not going to do that to that child. I want some visits. I want some things to happen. Then I'm going to do it if all is well. But I'm not going to go through the ICPC because I don't have any question before me of fitness. I think that might be how some people are going to look at it, but we're going to see. It's going to be interesting because I'm sure, folks, I don't want to deviate on ICPC too much, get me going on that, but I do think, I assume most of you are aware that there's a lot of tension going on around the country regarding the constitutional rights of parents who've not been accused of abuse or neglect, now being made to go through a very lengthy process of an ICPC. Why? That interferes with their constitutional right to their children. And there's a huge lawsuit that has been brought against the ICPC on that. In the meantime, this has been part of their response to try to clarify that you don't always need that when you're talking about a parent. All right, but people did hear, before I get everybody all worked up, we don't have to use it for parents anymore. It is, you have to make, the court has to make that finding, not the parent it was removed from. No supervision or services are going to be requested. This is going to end the case, and the court has no issue of fitness before it. Okay. So talking about, again, getting a hold of father, these issues intermesh, these time-bound issues, these concurrent issues intermesh with each other, because locating the father then also is an important issue regarding whether or not it might be an ICWA case, whether or not the father might be the person who has Native American heritage that might make the case ICWA, the father being able to be located so that we can talk about relatives, and that problem of someone showing up later. The father showing up later means perhaps we've lost a permanency option, we've lost an opportunity to build a relationship so that we can feel comfortable about the child going there. And certainly it causes, no doubt about this when we look around the country, it causes the most amount of legal delays. If we're looking at a termination or a voluntary surrender by a mom, and we haven't resolved this issue of who the father is and what rights he may or may not have, usually ends up in a huge legal delay. What can we do about this? Yes?
I'm not an attorney, so does fitness equate with safety, or when we're talking?
It's a brand new reg, and we will have to see how the courts will rule on that. But I think the choice of the word fitness is quite interesting, because fitness what does that mean? Does it mean safe, or are we talking about, suppose he's got a DUI from 10 years ago? Does that raise a question of fitness? I think it's going to be arguable. If you start from the premise that I would rather not use the ICPC because of the time frame problems, then this may be something that you would find helpful. If you start from the premise of, I don't really know very much about this person, I'd like to know a lot more, then you may be more desirable. You might be wanting the ICPC process and say, I have this issue, and Your Honor, I think that goes to fitness, and I think you have to use the ICPC for that reason.
Just one additional comment, whereas I think we do a great job with the pre-hearing conference identifying or trying to father relatives. The point is, and granted, initially the parent may not want to say, we ask the question once, but we forget to ask a second time.
Yeah.
Every time you have a family team meeting, ask the same question over
Yeah.
again.
Yeah.
You know who Aunt Joe is, ask Aunt Joe who the
Right.
relatives are. So utilize it.
Yes, exactly. And again, I'm arguing that this should also be done in the courtroom.
Yes.
And I'm saying that the court needs to ask every single time everybody's in the room, what's the story on the dad? And suppose she said in the beginning, I have no idea who the father is. I was prostituting, my drug habit. Unless you got a barcode on every guy in town and you can run them through the machine, I can't tell you who it is, all right? Now, that could be true. Yeah, I'd like that. I did a barcode. That could be true, but, somebody finds out a few months later that the kids call somebody daddy, or somebody gets a phone call from paternal grandma. What? So I think what you have to do is continue to ask that question, and obviously in an appropriate way, but continue to ask the question, because we know people are reluctant to tell information in the early stages, and maybe for reasons not to screw us all up, maybe for reasons that they sincerely believe to protect themselves or protect the child, particularly if the person they see is violent or has a problem. Ideas about making sure we have information about dads as early as possible. I feel very strongly that the judge should ask the mom directly. Who is the father of this child? Can you tell us a little bit about it, especially in situations where been made known to the court that she has, at this point, not identified anyone. The agency, and I'm sure you do, have a diligent search process, but everyone should be aware of it. What is the way in which you use the parent locator process? That computer, the Child Support Enforcement Unit, that thing scares me. I mean, they have everything in there. Are you aware how many databases fill into that thing? That thing finds anybody. So, I mean, is that being checked? And is that being discussed in court that it's been checked, and what has come out of that? All attorneys should be asking their clients about this. Children's attorneys should be asking children in appropriate ways whether or not they identify somebody as the father and who that person is. And this has got to be something that happens really soon. I am a very strong believer in getting paternity testing done as quickly as possible. I believe that it's not only an out-of-wedlock situation, but I think sometimes, depending on the information people have obtained, it should be done in an in-wedlock situation as well. We all know that in our system we have a lot of cases where mom got married. Getting married is cheap and easy. Getting divorced is expensive and long, and we have clients who get married, and as far as they're concerned, they've ended the relationship with that person. They've moved on, but we've got these paternity presumptions in law that make things not very full disclosure. We're really going to stand there and talk about how the husband is the father when he hasn't seen her in 10 years and she's holding the baby in her arms? I mean, we know that's not his child, and let's make sure that we de-father the husband and father up the boyfriend in the beginning so that we're not playing really sort of games for no reason. Don't accept there is no father unless there's some information about why she can't identify. We really do know there really does have to be a father. But there may be situations in which she can't identify them. And question whether or not there might be some special services. Lots of information out there suggests that services that are directed at fathers, often run by programs that are staffed essentially by men, can be more effective, particularly with that man who hasn't really shown any particular interest with that child before, and that this kind of selected service may be very helpful. And here's one that I think troubles me a lot. Don't you have those cases where we do locate him, and he says, what I want for my child is to go back with the mom. I'm not in a position to take care of the child. Maybe they're incarcerated, maybe they've started a new family and that spouse isn't interested in the child coming in. Maybe they know their own limitations. And they say, my child should be back with the mother, and I want her to get off drugs and get rid of that lousy boyfriend, and that's what I want. What we owe that father is to be honest with them about it not working, if it's not working, because it's not fair then a year and a half later to say, well, mom's rights should be terminated, she's still with the bad news boyfriend, and dad's should be too, because he's kind of abandoned this kid. I mean, he needs to hear from us on a regular basis whether this plan that he has, that the child should go back with mom, is working or not. So that we're saying to him, you need to have a backup. What's your plan if your baby's mommy can't get her act together? Including if the plan is someone that isn't involving your caring for the child. If you're incarcerated for the rest of your life and your hope is that mom will take care of the kids, but now we've told you that mom isn't going to be able to do that, what is your plan? Where are your relatives or significant others that can come forward? How about the relatives? Relatives, of course, we all know are good resources, and in my linking of this to be also mandated, it's not only excellent concurrent planning, probably one of the most important concurrent planning tools, but it is federally required. Fostering Connections requires us within 30 days of the placement, not a year and a half later, but within 30 days of the placement, to be identifying relatives and to be doing what we can to actually encouraging them to come forward as resources. One of the things we know about relatives statistically around the country is that relative placement decreases the number of multiple placements children have and increases the likelihood that siblings will stay together. I mean, if you can think about it from the standpoint of your own family, I often use my brother's children as an example. Sometimes I'm worried that might come back to haunt me, but my brother has everybody has siblings that have issues, right? Or at least you think the siblings do. Maybe you're the sibling with issues and you don't even realize it. But my brother has his issues and he's got 3 children. I don't want to raise, my family's grown, I don't want to raise more children now, but what would I do if I got the call? My God, I wouldn't be able to get there fast enough to pick up those kids, right? And there's 3 of them. 3 of them's a lot. Would I say, gee, I'll take the girl, but not the boys? No. Relatives step forward, and they often are willing to do a lot to modify their lives and to keep siblings together. Is there a question, ma'am?
Yes.
You wanted to take my niece and nephew? Go right
I
ahead.
got grandchildren of my own I have to worry about them taking to adulthood. The relatives are a good resource to keep siblings together.
Right.
And Judge O'Neill brought this up. When you have a family of 4 children with 4 dads,
Yeah,
and grandma says, well, I'll take mine.
mine.
Right, but I
I
don't
can't
have
take the others,
time or
I don't know.
energy or whatever
Yep.
for the other 3.
Yeah,
There's this,
yeah,
put one child with grandma.
Yeah.
and separate that child from the
or find the
siblings,
foster mother, we'll take them all.
Put each of these 4
Yep.
children with
Yep.
a different
Yep.
family, if you can find
I call it trumping. What are the
Okay.
rules of trumping? The first thing I say is that, as we all know, maybe we don't openly say this, but as we all know, the maternal grandmother is the gold standard. Bow to her, because she is the likeliest person to take them all, right? So why not admit that? We know that. Look for the maternal relatives first, right? The next thing is trumping. Trumping, in my mind, is who has the right to say, I get these children in that scenario. The first thing is that parents trump everything. So if anybody's daddy shows up and says, that one's mine, that's like actually a country song now, isn't it? That one's mine, he trumps if he's fit, okay? And that separates sibs? Yeah, it does. Now we'll say we don't have that. What we have is paternal relatives. Well, the first thing we do is we really kind of try to get them to do it, right? Don't we? Look, could you, I'm so happy you stepped forward to take Johnny. Could you take little Susie too? I know she's not yours, but they have this incredible bond. They'd like to, it is amazing to me how many grandparents will take kids that they're sibs to. I see it all the time. I do tons of adoptions where the grandma, in my mind, will say, yeah, that one was my son's child, and that one was the sibling. And then she'll make some comment, I've really forgotten who I'm the grandma to and who I'm not, So that's the next option. And then you get down to the last one, where there's no trumping, and I think you have to figure out what you're going to do. I like to think of it this way. This is my own personal vision. I think siblings together first. So I want to see first, is there any way for the siblings to be together? And I would tell that to the paternal relatives. This is what I think. These siblings have to be together. Can you see in your heart any way to do this? How could we help you do this? Is getting more money and assistance to you part of that? What could we do? And then weigh whether or not I've got a situation where I might be able to achieve a lot of connection even though they might be separated. Could I find a foster home that's on the same street as paternal relatives so that the sibs are going to see each other a lot, they're in the same schools? Might that be the way to try to weigh it? This is one of the really tough ones we have, I think, really, this issue of half-sibs and trying to find appropriate placements for them. I'm convinced this is why we are so valued by the community and paid so much money, because we have to decide these very, very tough decisions. But I do think there's a way to openly discuss that with everyone, particularly at a family meeting, and maybe respecting the family saying, this is what's going to work best for us to be able to do it. I also think there's a very cool thing that happens a lot of times between care providers of people who are doing care for half-siblings. I just spoke to somebody last night on the telephone helping them hire me to do their adoption. And she says, I'm calling you because you're doing the adoptions of the child I'm adopting. You're doing all the adoptions of all the half-sibs. And we are all one big family. And we want to know, can we all finalize together on the same day? Because we are all each other's family now. And we, babysitting. Cool things like that happen, and that, I think, may be a way to look at it, too. Also, I want to report that I think relatives can do so much more than be resources. A huge issue around this country is what a lot of people are calling visit hosts, using relatives to supervise more natural visitation between the parent and the child. Maybe you've had this scenario, a big holiday is coming up, there's no caseworkers around who are going to want to supervise on Christmas morning. If they are, they should be made saints. But how about visit hosts, relatives who might be able to do that? They can provide extras too. Would they be willing to take the child on outings, do things for the child? Fostering, means a lot of limitations on kids, and maybe they can't do certain things that they would, as some of my kids say, real kids could do. And save the foster beds. There's no way you have enough foster care homes here. Nobody does. So save those beds for people who truly do not have a relative to be able to come forward. And if there's anyone that's going to do concurrent planning and understand that concept of taking care of this child temporarily, trying to help the parent get back to where they could care for the child, but then becoming the full-time caretaker of this child if that's not going to happen. If there's anyone who gets that and doesn't need it explained and doesn't need it to be labeled concurrent planning, it's a relative. I mean, just think, that's me and my brother's kids. Of course I would do anything I could to try to get the kids back, and of course I would raise them. How could that even, I'd be shocked if you didn't realize I would do that. What could we do in the courtroom setting about the relatives? Ask directly. If this has happened, and I sure hope it has, in that meeting, pre-hearing, in that team meeting ahead of time, then put it in writing. Let the judge see who are the relatives that have been contacted, who hasn't been contacted. If there was someone who wasn't at the meeting, suppose one of the attorneys for the parents couldn't be at the meeting. They might want to know, what's the list of parents that's been contacted, relatives that have been contacted, and what's their response? Because I can talk to my client. Is that it? Are there more people? Can we promote other people? If there are relatives who are sincerely interested, bring them to court. Bring them to court. Let them hear what's being talked about. Let them get that underscoring by the judge. I'm asking you, Aunt Sally, if you can take these children in and help us try to get the kids back to your sister. And I'm asking you if you can make that commitment, understanding it's temporary, and understanding that we may need even more of a commitment from you later. I mean, the judge saying that is a very powerful thing. It would be very helpful not only to have the letters that I've heard you've talked about, but booklets, because there's a lot of questions that people have about this. I'm sure there are here. Can I get public assistance if I take this child in? How would I become a foster parent? What happens if the child is getting some kind of disability? Can that check come to me? People have these questions, and why should we be shy about giving them information about that? I make an okay living. I tell people I steal and sell the soap from the hotels that I live in, but I make a pretty good living. But if I was taking my niece and 2 nephews in, I'd have to figure out how I was going to do it. And I would be asking questions. And some relatives might be really, uncomfortable. I don't want you to think I'm about the money, but I need to know that. And what Fostering Connection says is that we're going to explain all of the various options to these relatives. Which options would mean that somebody might help me pay for daycare? Which options would mean I get a caseworker to help me? Which options would mean I'm kind of on my own? ICPC requests right away. This is kind of an edgy thing to say, but I say it. And that is, why don't you just ICPC everybody that's out of state? That looks like a reasonable possibility. What happens with the ICPC stuff, in my mind, is very linear, right? We're at the point a year and a half into the placement when it looks like it's not going to work. And we remember that we've identified, or maybe they just show up, the grandma in Florida. And we say, okay, we're going to have to do an ICPC. And, even in the best of worlds, we know that's going to be several months, right? And I'm sure some of you have been involved in cases where that's gone on for month after month. Well, she has this problem. Well, she can fix that. We can do a new ICPC. What I'm suggesting is, if you have a person who looks like a very significant possible relative, even though you're keeping the child here, maybe in foster care, maybe with a relative, in order to facilitate reunification. A concurrent plan may be that grandma in Florida is going to raise the children. Why not start the ICPC process right away? If you get an ICPC thumbs up, which takes months and months, it's good for 6 months. So for 6 months, you've got that concurrent plan in place. 6 months, but what if it went fast and the 6 months ran out, then I did a lot of work for nothing. Because if you've already done an ICPC, first of all, sometimes they'll extend the 6 months if you ask them. And second of all, if you then have to redo, because it's long past the 6 months, it's a lot quicker and a lot easier because they're just updating when they've already done. Now, I've proposed this to a lot of people in a lot of places. And some people have said to me, geez, Margaret, if everybody did what you said and we were running around ICPCing everybody when the case come in, we could like bring the ICPC system to its knees with all these requests. Yeah. Okay. Placement resources should be at every hearing. If they're the resources, they should be there hearing what's going on. And of course, a big issue nationwide is this expansion on the concept of relatives. I call it the Kevin Bacon rule. Relatives have become whoever you can make some connection to. And for most folks, they've also become that person who is near and dear to the child. The godmother, the mother's a friend who's been like an aunt to the children, the child's best friend's parents. Didn't you have this in high school? Everybody I know had this. Somebody's dad had to move away and the kid was going to lose the last year of high school. And some family, right, there was always this kind of family. Except for that kid could move in with us. Or the coach had the kid move in, something like that, right? This happens. Does the child's friend's family know that this child may need some assistance? What we want to avoid is exactly what was raised before, what I call the pop-up. The relative who shows up later and you go, oh my God, this would have been a great placement. And then you have this horror show of a child who's bonded and connected to a lovely foster home who was getting all ready to have a big adoption party, and you have a perfectly good relative over there, and then we have this agony. We want to avoid that by reaching out to all the relatives as quickly as possible and talking to them about what I call stepping up to the plate, timeliness, and bonding. In the context of maybe you've had a relative that does this kind of tough love response, right? The relative says, you know, I haven't had a lot of contact with my sister in a long time because we've had to cut her off. She won't get off the dope, and we've tried, that's it, we've had to move on. And so now you tell me the kids have gone into care. I'm not surprised. And maybe this will be the thing that will make my sister wake up. Maybe she'll finally get off the dope, lose those loser guys, because now her kids are in care. And I'm not going to take her kids. Because if I take her kids, it's like, you know, it's like that codependent thing. It's like I'm going to help her, and she won't get off the dope, and she won't leave the guys. No, better that they... We need to talk to these relatives and tell them this is not about your sister as much as it's about her kids. And using the kids as the foster care pawn, not good for the kids. And you might not be able to step in later when you think it's not working. And you need to know a significant number of people who have long-term mental health or substance abuse problems don't get their act together. This might not cause your sister to wake up, and then you will not be the connected, bonded person that we would want you to be to adopt. So I think we need to hope relatives listen to us say that your gorgeous nephew or your wonderful grandchild is going to, someone's going to fall in love with them and want to take care of them, and then we're going to have this difficulty about whether or not bonding should be blood. How about outside? We talked a little bit already about ICPC. I recommended that we look at ICPC requests right away and that you follow through that reg to see if it is apparent whether or not you even need to use the ICPC. I do think sincere out-of-state relatives are kind of not really in a good position. Unfortunately, if we're really going to be aggressive about wanting to reunify, we are not going to want to send the children to another state. But I think a couple things within full disclosure could be discussed. First of all, maybe we don't always give permission to parents to make a decision that they can't do it. I think about myself, this very young, I look at the pictures and it's frightening. This very young public defender, no children, and I had these clients, right? And I'd go, such a chill. We're going to beat the department. This caseworker's probably lying about you, and we're going to get you the help, and we're going to get this kid back. I mean, that's how I was. And I wonder now, when I look back, whether it's possible that I did not give my clients permission to say to me, I can't do it, I don't want to do it, is there something else? Can I make arrangements for my mother to adopt this child? And I don't know, sometimes our energy around wanting reunification doesn't always say to the parent, so they've located your aunt in Georgia. She seems wonderful. You know, I just want to let you know that we could talk about her raising the child if you're not wanting to be involved in this reunification, if you feel like that's not a good idea. Seems like that ought to come up, not just from the caseworker, but frankly from the attorneys who are involved as well. If there is a situation in which there is that out-of-state parent, out-of-state relative, and it looks like it's going to interfere with reunification, then we need to think about what is it really going to look like if it's a concurrent plan. That person's going to need to have contact and communication with the child, right? How are we going to work that out? Are they going to visit? Well, maybe they're going to visit, and maybe that's going to be in January. Maybe they're in Florida, and maybe some caseworker needs to fly down with them on a Friday to help them visit. There's lots of options here, but they have to have some kind of contact, right? And truth to the foster parent. That you need to be honest and full disclosure to the foster parent. We have a relative. This relative is an extremely likely placement resource if the mom can't get the child back, and you need to know that. Not that we are asking people not to fall in love with kids, but not for that foster parent to hear a year and a half into the case, oh, by the way, we always intended to let the child go with grandma in Florida if things didn't work out. Do we have an Indian Child Welfare Act case or a child? The court should be asking this and asking until we have a definitive answer on that. All the attorneys should ask their clients, even if the client says, I don't want that information told. Of course, we respect clients' confidential information, but advising, as lawyers should, clients that if that information comes out later, if we don't bring it out now and it comes out later, it could very much compromise your case and could be very serious. What could be the more helpful concurrent situation if there is in fact a tribal connection? Now we've got more assistance available, often opens up lots more options for relative placement in particular. What kinds of things can courts and attorneys do? Much of this information we've already gone over, so I'll just kind of summarize it for you. Making sure that we're looking at paternity issues as quickly as possible, making sure that everyone's aware of where the case can head, disclosing ASFA timeframes. I actually saw this in Chicago once. I have to tell you this. I saw this. I'm not sure I'm sold on this idea, but it was a very creative idea I thought that the judge used to talk about ASFA timeframes with the clients who can be so very concrete. The judge had gotten, I think Hallmark is the one that does it, makes those little paper calendars that you get in the beginning of the year, and I think he'd gotten a box of them or something. And he was bringing cases in, first or second appearance, when children were being removed, and he was talking to the parent about the importance of starting right away, as immediately as possible, on services to try to resolve the issue. And he would fish out one of these calendars, and he would circle a month in it, and he would say, this is the 15th month right here, here it is. That will be the month they will be back here with the termination petition if you're not able to do it. We're going to do everything we can. He was kind of a gruff fellow, and he used kind of surprising language for being on the bench. But he said, basically, I'm going to kick that caseworker's butt to do everything possible to help you. I will move any mountain to help you get this child back, but I will have no problem terminating parental rights at this point if it hasn't happened, and you need to know that. It was a little Chicago and a little gruff, but the underscoring by the judge of, I know what the time frame is, and I want you to succeed, was incredibly helpful. That the courts and the attorneys are stressing to everyone that, and their clients, that reunification is the #1 objective. But there is going to be open discussion about other kinds of objection, open communication about placement resources, and court orders that reflect expectations. This is a big issue of mine. I understand from what a lot of people have already mentioned to us here in the state that a typical pattern here might be the court order with the service plan kind of attached to it. But I do think this is something we could all work on, and parents' attorneys in particular might be helpful in this regard. Do you have the sense sometimes that the parent really doesn't understand what it is they have to do? For example, the judge told me to go to parenting. Here it is. I went, I got a certificate. Well, is that how the parent perceived it? That if I just went to parenting and got a certificate, I'd get my child back? Or did we make it clear to the parent that, when you're having your supervised visitation, we would like to see you demonstrate what you've learned in the parenting class. We'd like to see you use appropriate methods to discipline little Danielle that you've learned. Have we helped that parent see that it's the behavioral issues we're ultimately looking for, not just that I went to program, but that I'm actually attempting to remain sober and I'm making plans when I do have a relapse as to how I'm going to deal with that. Obviously, courts should support collaboration if it turns out that the case is going to be transferred to the tribal court and issues regarding permanency will be handled there. Aggressive monitoring of cases. A number of people that we've talked to here in the state have talked about increasing frequency of coming to court, which as a lawyer I know sometimes is more problematic. Do I have the time for that? But increasing the frequency of coming to court means a lot more aggressive monitoring of what's going on. We're all human. And when the court date is approaching, you finally do the thing that you should have done. If it's clearly said at the last court date, this caseworker, the defense attorney, the GAL will do the following things until when we're back in court, and then you're back in court, that's going to end up resulting in that being done. Stakeholder trainings like we're having here, talking about what is actually expected of everyone in the hearings, making sure that the court says I'm holding people responsible. I hesitate. I'm always a little uncomfortable when I get to the third point here on this screen, but I think it's important to say we aren't just all holding hands and singing Kumbaya, okay? There is a court there, and that court can hold people in contempt. That court can order that supervisors and administration appear if things aren't going to happen, and I don't want to lose money. None of us want to lose money. That doesn't help anybody. But ultimately, the court has the sanction. If you're not making reasonable efforts towards permanency, if I ordered you to do certain things and they haven't been done, then I can make a finding of no reasonable efforts.
So in the context of stakeholders,
Yeah.
you're not just talking about case managers.
No.
You're talking about whether it be guardian ad litem, whether it be defense
Yeah.
counsel. I mean, it's everybody is accountable to that, not
Right.
just the case
Absolutely.
manager.
Attorneys are ordered to do certain things, and if it's not done, there can be consequences as well. Some of us attorneys, it can be a bit of a badge of honor to be held in contempt. I got cuffed once. It was fabulous. We talk about it forever. But, the bottom line is we also can be held. Okay, other kinds of ideas, and I'm realizing our time frame here. Let me move through quickly. Many of these things we've talked about already. The judge supporting a family meeting, ordering that there be a family meeting held. The judge asking for family tree information. Who are the relatives? What have they said? We know that when the judge requires this of us, we're going to get these things done. Making sure when the relatives show up, has everyone explained to you about the financial options? Do you have questions about that? Making sure in some way that feels appropriate in your state that the judge is also actively discussing the concept of concurrent planning, underscoring that full disclosure. Asking specifically about it in court. All right, we've talked now quite a bit about what efforts have been made to reunify the child. I'd like to know what efforts have been made about the grandmother as being the possible full-time resource if mom's not been able. An actual conversation about not just what the concurrent plan is, but what's actually been done to forward that concurrent plan. Making sure that everybody's been checked out regarding possible placement. Visitation and court orders, I'm told that is done here in Nebraska. Requesting information about how that's going, making sure the case plan and objectives are actually reviewed openly in court, asking what's the holdup in particular services, what can we do to resolve that, possibly having more frequent formal meetings in court if that would be of assistance, making sure that everyone knows that the court wants the foster parents present and wants the foster parents to be able to give information about what's going on, talking about input from the child and how the court's going to handle that, and what I call being careful about resetting the bar. We all know this happens in two ways, I think, in child welfare. The first one is this behavior out here is what puts kids in care in Nebraska. This behavior is neglectful but doesn't rise to the level of putting kids in care. But once a child is in care, do those rules change? I think so in a lot of places. Now that the child is in care, I'm not tolerating any problems in this area. The same action that would result in some help and services but keep children in the home means I'm not taking the child out of foster care, not releasing the child. We have to explore that more. Do we reset the bar and make it harder for the child to go home on the same behavior that we wouldn't remove them on to begin with? And also, this resetting the bar concept also happens with services. We put the child in care, and the issue is we think substance abuse services. We order all kinds of things. The parent does it, and then we say, yeah, now we need mental health services. And now the reality of that is sometimes we don't discover that there's a problem until we're in there further. But we need more honesty about that we may discover more issues, things might happen, and we need to be concurrent in our services. You know, does it need to be that you have to wait for this one service to end before you do another? What could attorneys do who are representing agencies? Consider bringing cases back more frequently if things aren't going well, making sure that it's very clear to the court when an objective, the goal needs to change, and making sure that if you're having goal changes occur, objective changes occur, that you're cognizant about reasonable efforts is assessed on the objective that was in place when you brought the case to court. Seeing if it's possible to either in the court order or from the mouth of the judge have more statements about behavioral issues. We want you to go to substance abuse, but we also want you to remain sober and have a plan if there's going to be any kind of a relapse. Parents, attorneys, I think, could be more aggressive about explaining the benefits. And I say this to some clients that I represent. I say, you know, most parents in this world think about the fact that they might die before their children are fully able to take care of themselves. And many parents in this world, either in a formal way through a will or an informal way, and maybe godparents or relatives, ask someone or designate someone, you are the person I would want to take care of, want to have to take care of my children if something happens to me. I'm asking you to do the same thing. We don't know ultimately what's going to happen. We are going to try very hard to get these children back in your home. But I want to know what you would want to have happen if your children aren't going to come back. And that's going to be our backup concurrent plan. They could have a concurrent plan, but we can have a concurrent plan. We could argue to the court that our concurrent plan is better than their concurrent plan. Talk about that openly with the client and see if they have a better understanding of what should go on. Request a lot of information about visits. Make sure that visits are being used not only to access the children, but as a way of showing that progress is being made in changing the parenting. Help the client develop an alternative if that's necessary. Explain to the client why identifying the other parent or the relatives may be better, even if they're problematic, so that those issues come out right away. This concurrent planning really can benefit parents. It can, in some instances, not all, but it can, in some instances, really create more of a sense of urgency. The person is much more aware of the limited time that they have, and that may motivate them. I even think sometimes our clients are motivated when the other parent shows up. I'll be damned if he's going to get the kids. I'll do what's necessary. I don't want my kids to go to my mother who's been judging me and giving me hassles all my life. Well, those things may end up actually being a motivation. Allow the parent to be involved in some way in all of the options. Don't be so blinders about wanting your client to know just how hard you're going to try to get the child back that you're not listening to cues that they might want to choose other things. And I know this was said, but boy, I just have to say this with all my heart. I have been in this business for a long time, and I have done thousands of conditional surrenders and open adoptions of children in foster care. I believe the number one reason that can happen as a positive response when it looks like the child can't go home is the relationship that's developed between that birth family and that resource family or that foster family. I don't have any doubt whatsoever. Sometimes I think it even is the birth family saying, I'm so unhappy with the agency. I so don't like that caseworker who really didn't help me, but I love that foster mother who always spoke respectfully of me to my child, who cares about me, who I believe loves my child and will raise my child well, and I believe will let me have some part of that. That's what really makes people make a decision to do that, to give the child up but to still have contact, which can be immensely possible. The role of the GAL or the CASA or the advocate for the child, making sure that you are meeting with everyone, doing that wonderful job of making sure the judge is hearing all the information that needs to come out, not just the information that might be coming from the other parties aimed at achieving their particular goal. And I do think if there's anyone out there that should be screaming about concurrent planning, it should be the GAL. I'm the person who wants what's best for this child, and I can see that we need to plan for several options. If some of you have children like I do in their late 20s and early 30s, I wish I had a nickel for how many times I've said to my kids, what is your plan B? Okay, if you don't get into Harvard, what is your plan B, right? All the time. And you really want this for that child that you're representing. Yes, this is what's going on, but what is our plan B? And for some of us that have been in this business for a long time, I know you don't have a crystal ball, and I know and sometimes the most surprising things happen, but don't you pick up a lot of cases and say, the likelihood of this child going home is much lower than many other kinds of cases. And I really need to be aggressive from the beginning, not pretending that, oh, well, everybody's going to get their kid back, but realizing that this might not happen for this client and making sure that that's openly being addressed and efforts are being made to achieve that. Keeping the focus on the child. It's the parent's attorney's job to be dealing with the parent, but your job is to keep reminding everybody this is about timeframes for the child. This is about the development of the child. This is about making sure there are options for the child. That's really what it is supposed to be about. Not to sing parents' attorneys because they're doing what they're supposed to do. We really do see that concurrent planning benefits children. It reduces the number of placements, attachment difficulties. It definitely, where states are aggressively doing it, and Nebraska has endorsed it. It is part of their policy. They have a checklist. They do not mandate, but it would be fair to say Nebraska does concurrent planning. It really does work if people are aggressive about it, and I'm here to say that I really think this is a place where the courts and the social work can really work together. Even though I do believe in being an attorney and not a social worker, and making sure that I argue and an advocate and be in the adversarial setting where it's necessary. But this is a situation where you can do what we do all the time as attorneys and judges, help people see that we need to look at plan Bs, that we need to look at other options, and that we need to make sure those things are in place so that that option can happen. All right, they stayed in there so patient. It's 10 of 11. Can we take a little break till 5 after 11? I know you haven't had a chance to ask some more questions and have some more discussion. So when we come back at 5 after 11, we'll open up the floor and see if people want to talk a little bit more and decide what our next steps will be. So it's 10 of 11. If we can take a break till 5 after.